Okay, so I'm Linda Hutchinson, and on behalf of the League of Women Voters of Colorado and the News Access and Literacy Task Force, I'd like to welcome you to our presentation on Colorado Open Meetings Law and how it contributes to people's right to know. Our guest is Jeff Roberts of the Colorado Freedom of Information Coalition. He's the executive director of the coalition. Jeff worked in journalism and public policy before coming to the Freedom of Information Coalition in 2013. So before I start, I need to say something about the League of Women Voters. The League is a grassroots organization, and we are nonpartisan. We do not endorse political parties or candidates, but we do take positions on issues, and that's why we are here today. We are fierce defenders of a citizen's right to know. And unfortunately, recent years, let's see, I'm trying to double duty here and let people in while I'm talking. Recent years have seen a trend toward a more opaque government in Colorado. This year, the League has joined forces with other transparency advocates, and we're working toward developing a ballot initiative that will allow voters in 2026, not this year, but 2026, to enshrine transparency in our Constitution. So Colorado Open Meetings Law is part of that transparency, and Jeff is here to explain it tonight. Jeff. Oh, and if you have questions, you can put them in the chat or raise your hand, whatever you want to do as we go along. Thank you.
Hi, everybody. Thanks for having me on the Zoom this afternoon. As Linda said, I'm Jeff Roberts. I'm Executive Director of the Colorado Freedom of Information Coalition. If you're not familiar with CFOIC, and I know some of you are familiar with it, we are a 501c3 nonprofit that educates the public and journalists in particular in Colorado about their rights under the open government laws in Colorado. And we also advocate for government transparency and press freedom. So those things are pretty important, especially right now. And well, they've always been important, but maybe they're even more important right now. And we work with other groups like the League of Women Voters and Common Cause and some others in the legislature to try to either help make these laws better for Coloradans or to oppose efforts to close off access, which unfortunately, like Linda said, is what we've been doing a little bit too often the last few years is playing that defense in the legislature. But so the main things that I do.
Face.
I'm sorry.
I think Gail, could you mute yourself? Could everybody mute themselves, please?
I thought there was a question. Yes, the main thing I do is run a hotline, a Freedom of Information hotline. And over the last dozen years, I've responded to 6,800 inquiries to our Freedom of Information hotline. So that's a few a day, usually. Also write about these issues. I'm going to share my screen and go to our website. Let's see, I have that up in the background.
And while you're doing that, Sonia wants to know how the hotline is accessed.
Oh, the hotline is accessed in all sorts of ways. You can call me, you can email me. I get questions on Twitter, X, Blue Sky, Facebook. Some people text me questions. Any way they can get a hold of me, and I try to respond as quickly as I can and as thoroughly as I can. And about 60% of the questions over time have come from journalists, and the rest, 40%, from the public, and sometimes people in government. ask us questions as well. So our website is coloradofoic.org, and you'll see several things on there. We have lots and lots of resources. We also are nonpartisan, so we just help anybody. You'll see a blog on there. As a former journalist, I spent many years at the Denver Post. I consider open government like my beat, and so I write about these issues. It's part of our mission to educate people, Coloradans, about the open government laws. So you see a lot of that on there. Court rulings, legislation, First Amendment issues. Our Sunshine Laws Guide is something that we put online about 3 years ago. And it's very extensive. It has all sorts of categories of information that you can just click on and go to right away. And you get an explanation of what the law says, but also a link to the law. And if there's case law, court decisions, you'll get links to that as well. And the great thing about having it online is that I can keep it updated whenever there's a change to the statute or some Court of Appeals or Supreme Court ruling that's relevant. I go in and update it. And so it's something that's out there. It's free to use. And if you know people that would be interested in this, I know there are members of the league that do use this. Please let them know. The other one thing I want to mention is that we put out a newsletter. You can sign up for that and keep in touch with what CFOIC is doing. So I'm going to switch to some slides. Let's see. Getting these messages here. Okay, stopping share. And I'm going to share my slides. Okay. So there we go. Okay. So we're going to talk about the open meetings law today. We only have about an hour, but this is a slide that shows all the open government laws, Colorado and nationally, just to show you how the open meetings law fits into that. We have the National Freedom of Information Act. We have 2 public records laws in Colorado, the CORA, the Colorado Open Records Act, which covers everything except law enforcement records, which are covered by a separate statute called the Colorado Criminal Justice Records Act. They operate very differently. And we can talk about that maybe in another time. The Supreme Court has rules for both court records and also the administrative rules of the judicial branch. So the judicial branch is not subject to CORA, it's subject to its own records rules. And then, of course, we have the open meetings law, which is what we're going to talk about today. And I always like to take a moment and talk about why all this stuff matters. Why is it important to have these open government laws? And the Colorado Supreme Court, I think, said it really well in a decision in 1983, in which they upheld the public's right to attend legislative caucus meetings in the Colorado General Assembly. And they said that a free self-governing people needs information about government to shape its views about policy and to vote intelligently in elections, and also to hold government accountable. So that's what it's all about. And I know the League of Women Voters cares deeply about all of that. So when the open meetings law was 50 years old, which was in 2022, it was adopted by the voters of Colorado in 1972. I did some research and I wrote an article about this, which you can find on our website. and included some personal memories too, because I had um, sort of a connection when I started at the State Capitol Bureau for the Denver Post in 1985. And in the desk, this old roll top desk that I was given to use, I found some bottle openers with Coors imprinted on them. And I asked what that was all about. And it turns out that our press room in the state capitol was where the reporters used to sit around and drink beer and play cards until um, legislators came out of closed meetings, and this was the remnants of that. And so in my I talked about that in this story, but so the Open Meetings Law, the Sunshine Act of 1972, not only included the Open Meetings Law, it also included financial disclosures for certain elected officials and lobbyist disclosures. And a Denver Post reporter at the time who was covering the State House, who is now 84 years old and still a member of CFOIC's board of directors, Fred Brown, started looking through the first batch of lobbyist disclosures and saw $140 a month spent by the Beer Distributors Association stocking the state capitol press room. And so Fred wrote this story in about paragraph 16 of an 18-paragraph story, mentioned that, and that was the end of that. No more beer for the state capitol press corps. So the act of 1972 didn't only open meetings in Colorado, it also changed the way business was conducted at the Capitol for the press as well. It was sort of the old way of doing things, and they moved into a new era. So the Open Meetings Law starts with I think, a very powerful statement, a declaration that it is declared to be the policy of the state that the formation of public policy is public business and may not be conducted in secret. That sets the tone for the rest of the statute. That's what it's all about. Excuse me. And at first, that it really only applied to the legislature, and later it was amended to apply to all local governments in Colorado as well. And even just
Did
recently,
you turn it off?
Yes,
Thank you.
I'm sorry,
Is that me?
hit me in place.
is there a question?
I don't think so. I think that somebody's microphone isn't muted. Everybody,
okay.
please mute unless you want to ask a question, please.
Oh, and also if you're putting questions in the chat, I may not be able to see them. I probably can't. So somebody, Linda or someone else is going to have to read them to me because of
Yeah,
this.
I'm following it. They said they
Okay.
were laughing about your comment about the beer. Everybody said commented
Oh.
in the chat.
Okay.
Okay.
Yes. So just last year, actually, there was a pretty important ruling about the Open Meetings Law and whether you have the right to challenge a violation of the Open Meetings Law anywhere in Colorado. There's a lawyer in Pagosa Springs who's made it part of his business practice to sue school districts around Colorado. He says he's an open government champion, and I believe him, but he also goes in and represents himself in these lawsuits instead of having clients, although he has represented some clients in some important cases as well. But he sued the school board. He lives in Pagosa Springs, sued the school board in Elizabeth, and the school board in Elizabeth said, well, wait a minute, you don't live anywhere near here. We don't think you have a right to sue over an open meetings violation. And this went to the Court of Appeals, and they said, and we actually wrote an amicus brief defending what he was doing. And the Court of Appeals said it doesn't matter where you live. If there's a violation, you have the right to challenge that. And so that's kind of an important thing.
Okay, very.
Yeah. The Court of Appeals said that the General Assembly intended a broad right to a transparent government for everyone in Colorado.
Mhm.
So what is meant by an open meeting? It's not just the school board or the city council gathering in person to meet about, have their regular, meetings twice a month or whatever they do. It can be any kind of meeting convened to discuss public business. And that could be in person. It could be like we're doing right now over Zoom. It could be by telephone or by email or text message or Slack or anything like that. And if it's a local public body like a city council or a school board, if 3 or more members are discussing public business, then that's a meeting that the public is entitled to attend. And if it's a state public body, it's 2 or more members, although there's now a big exception to that, which I'll get to in a second.
Jeff,
And a
I
public,
have a question. Sonia wanted to know if the attorney from Pagosa Springs who filed all the lawsuits, did he make money from the lawsuits?
so this is Matt Rohn, and I've done articles about Matt, and I've met Matt, and he often settles with the various places that he's filed suit against. When you talk to Matt, you will truly believe that he sees himself as a champion of open government. But there are definitely people that think that if he's going to do this, he should not be representing himself. He should have clients, and he does have clients, and he's good at what he does. So kind of mixed feelings about it all. But yes, he's had many more than 100 of these lawsuits, and has filed some this year. Anyway, so a public body can not just be the board, the school board, the council, whatever, but it could also be an advisory board to that public body. This question comes up sometimes whether a certain type of public body or a certain type of board fits the definition, and you have to dig into it a little bit and look at how it was created. So what meetings does the open meetings law apply to? It applies to meetings where public business is discussed. And there is actually an interpretation by the courts, the Court of Appeals, about what is meant by public business. And so there has to be a meaningful connection between the meeting itself and the policy-making powers of that public body. So it's pretty much anything that they do, although there are exceptions sometimes. So when this just came up kind of recently, and I'll talk about this case a little bit more, but the Douglas County Commission, it was sued recently over open meetings violations. And one of the allegations is that they were talking about their interest in becoming a home rule county at different events that they didn't necessarily convene. So political groups, having them in attendance. So the question there is, was that part of their, was it public business for them to attend these meetings? If they're talking about the home rule issue, I think there's definitely an argument that yes, but others were saying no, And the judge in that case sort of dismissed that idea that these were public meetings that the public was entitled to attend. But a more straightforward example might be a you know the county sheriff briefing the county commission on some crime that had happened, and there's no action or anything that the county commission would need to take. They just need to know about it. So that might be something that they could exclude the public from.
Okay,
So
I have,
that's,
I have a
yes.
couple questions. Sorry, I keep interrupting. In the case, let's see, Jan from Uncompahgre League would like to know, in the case of county government with 3 commissioners, what is the quorum that constitutes a meeting?
It's 2. So because it's 3 or more or a quorum, whichever is fewer, and I should have made that clear, that's a meeting. 3 or more or a quorum, whichever is fewer. So in the case of a 3-person county commission, it would be 2.
Okay, and then Karen Sherman Perez asks, how do you prove an open meetings law violation? There appear to be open meeting law violations with the Montrose Board of County Commissioners seen through clearly unilateral decision-making by 2 or 3 commissioners during meetings before discussions have taken place.
Yeah, that's a good question. How do you prove it? Because if you went to court on it, and I'll get to this, but the way these laws are enforced, the ways our open government laws are enforced in Colorado is through the courts. Someone would have to, file a lawsuit. But how do you prove it? There are various ways. Sometimes, it's obvious if they come out of a meeting and they've they don't discuss it in public, but they just vote on something. Okay, so when did they actually discuss that? Or if they did it, um, uh, you know, outside of a public meeting, you're looking for whatever you can see. Sometimes you do Quora requests for emails and text messages to see if you can see something there. Sometimes people inside of an executive session, this happened with the Aurora City Council, where there was a decision to stop censure proceedings against Danielle Jurinsky, one of the council members, and the decision was made in an executive session. You're not supposed to make decisions in executive session. And a couple members of the council told a reporter about it. So there's various ways you can possibly prove it, but a judge is going to want evidence in order to take action on that. And sometimes if something is happening in an executive session that shouldn't be happening, they would then listen to the recording, the judge would, and decide whether a violation occurred. If there's no recording, there's no executive session violation, but other things, sometimes you have to find other ways. So the Douglas County School Board, 4 members, this is now 3 years ago or something, 4 members of the Douglas County School Board had a series of discussions outside of a public meeting about the superintendent, eventually decided to fire the superintendent. The three other members of the school board were not involved in those conversations, but they learned about it and kind of blew the whistle. So there's various ways that can happen.
Okay, I have a question too. On when you went back and said local public bodies, the limit is 3 or more members. That's an open meeting. But state public bodies, it's 2.
Yes.
Why is there a difference?
I think that's a good question. I don't, the open meetings law, when it was initiated in 1972, said two or more. I personally think three or more makes more sense. And we'll get to the legislature in a moment, because two or more members of the legislature doesn't seem terribly workable. Three or more, maybe, especially when you take into account what's happened recently with the legislature. But why it was picked as two, I don't know the answer to that. There are a bunch of state boards and commissions that operate kind of like local public bodies do. So why is it two for them and three for a local public body?
Yeah.
I don't know. So we just talked about the definition of public business. And again, that has to have a meaningful connection between the meeting and the policymaking powers of the public body. That's how the courts have looked at it, and that's what still applies to every public body except for the legislature. Because last year, the legislature decided to change the law as it applies to state legislators. And this is something that we opposed. The League of Women Voters opposed. Unfortunately, we were kind of, both of our organizations were somewhat alone in this opposition, and couldn't stop this from happening. So what the legislature did in Senate Bill 24-157 was change the definition of public business as it applies to them. It's not just something that relates to their policy-making function. It has to be very specific to introduce bills and resolutions and other matters that come before a statutory committee or an interim committee. The other thing that this bill did is that it allows legislators to communicate electronically in an unlimited way without it being a meeting. So they can now talk on the phone, they could talk by email, they could talk by text message in an unlimited way. And of course, if in using those types of forms of communication, there's no way for the public to attend that meeting, and it's not a meeting. So they have excluded the public from a lot of their deliberations, except for those that actually, we can see in committees and on the floor. The reason they did this, they were sued a couple of times. So two members of the House, very unusual lawsuit, two members of the House sued their own caucus and also the Republicans. So these were two Democrats who sued their own caucus and then also sued the rest of the House for open meetings violations. Excuse me. And that lawsuit was settled. There was another, in that settlement agreement, they agreed to stop auto deleting their messages that they were sending to one another. So using Signal and other apps to communicate. But that, of course, doesn't apply anymore because of the way they changed the law to allow them to communicate by Signal or text message or email any way they want to anymore. And it's no longer a message, or it's no longer a meeting under the law. There was another lawsuit that the legislature lost, and this had to do with something called quadratic voting, which is something that former Senator Hansen came up with. as a way to, and it wasn't something he invented, but he found out about a nonprofit that was offering this software that was a way for legislators at home in their pajamas to weigh in on how they felt about bills that affect the state budget and to prioritize those bills. And then, excuse me, the Democratic caucus in particular would use the results of this to rank and decide, which bills got to pass and which bills did not. The problem with all this is it was anonymous and the public did not know anything about how individual lawmakers were voting. And when reporters tried to get the records of this, they were told that it was work product. So it was a very secretive system. And when a conservative group sued over this, there were stories that KUNC did on this, and they quoted me and others about it. And then this conservative group picked up on it and sued the legislature and won. But under how the legislature changed the open meetings law as it applies to them, they could go back and do this again if they wanted to, and it would no longer be a violation of the law. So one of the things we saw as a result of this new law that they passed to exempt themselves, you might remember that before after the last, not this past session, but the one before, there was a special session on property taxes, kind of a big deal. And the Democratic caucuses in both houses actually excluded reporters from their meetings before this special session started. And they used this new exemption to say, well, we can do that now. So that was the first time I'd heard about legislators excluding journalists from their meetings. It kind of goes back to beer in the press room and playing poker while they, waiting for legislators to come out of the meeting. In this case, it was a meeting on Zoom, or a series of meetings on Zoom that reporters were kept out of, and they probably weren't playing poker and drinking beer while they were waiting for the legislators to come out of those meetings. But that was a very concrete example of something that happened after they changed the law. And it's one of the reasons why, as Linda said, we are now discussing, whether some of these rights should be enshrined in the state constitution. So stay tuned for that. So back to the open meetings law as it applies to, generally, the public meetings must be preceded by full and timely notice. And for a local public body, so like, once again, a town council, a city council, a school board, a county commission, that's supposed to be at least 24 hours ahead of time. And that should include specific agenda information where possible. And there's actually some case law about that says that the notice is sufficient as long as the items actually considered at the meeting are reasonably related to what was on the notice. So it's kind of flexible. It gives the public bodies some flexibility, but it's if they know something is coming up, they need to notice it, and there are emergency situations that happen sometimes. So very recent example the other day, the co-publisher of the Ouray County Plain Dealer contacts me because the fire district board in Ridgeway was having a meeting that night, but had never noticed it. They'd never put out a notice. The newspaper called or emailed someone on the board and said, this is about when you have your meetings. Are you meeting tonight? And they said, oh yeah, we're meeting and here's the agenda and stuff, but they'd never put out a notice to the public. And so when she called them out on it, they actually canceled the meeting the other night, saying, because she was gonna write about it. You're not letting the public know that you're having this meeting. So let's see. Minutes must be taken and promptly recorded. That's about all it says. It doesn't say how detailed, how good the minutes must be. And these days, hopefully, a lot of meetings are done on Zoom or at least on YouTube or something like that. And you could go back and look at the recordings, but that's only for sort of the bigger meetings. It's not for some of the subcommittees and things like that, or maybe even the planning commission and all that. Minutes sometimes are thorough and sometimes they're not. And for local public bodies, minutes are only required at which the adoption of any policy or position happens or it could happen. So sometimes you see a city council have a study session, but they do not have minutes for that study session because they're not adopting anything. And that's how they get around that minutes requirement.
Jeff, I
Yeah.
could say something about the minutes. It's been a small problem or maybe a larger problem sometimes for Observer Corps because all of these meetings, they don't approve the minutes until the following meeting. So they don't want to show it to anybody. You can't go find those minutes anywhere. So if you're a public person wanting to comment, like something goes down in that meeting, maybe you missed it, but if you knew, you would show up at the next meeting to comment about it. But you can't know that it happened until those minutes are made public and approved at the next meeting. So now you're like two meetings behind. Or if you're an observer who just wants to check, names and roles or something like that, you have to wait.
You can do a Cora request for unapproved minutes. They are still made, maintained, or kept by the government entity. As soon as they are written down, they are a public record. Even though they haven't been approved by the board and the board is probably reluctant to release them, you can certainly say these should be subject to Cora, and I would like to have them.
Oh, good to know. I bet I would be told you can get them after the next meeting when we approve them.
You may be told that. I don't think that that's accurate. However, I once even wrote a blog about this question and talked to the lawyers about it. And you can't make an argument that it's a work product, or they can't make an argument that it's work product, which is deliberative materials prepared for elected officials, because minutes aren't deliberative. They just are. They are a reflection of what happened at a meeting. And so it's made, maintained, or kept by the public body or the government entity, which is the definition of a public record in Cora, and therefore it should be subject to Cora.
Okay, I'll let you know.
Yeah.
Pursue that.
So this is an example of an agenda that was not adequate, and there was a lawsuit over it. This is the Woodland Park School Board a few years back that discussed a very controversial memorandum of understanding with a charter school. And all it said on the agenda was housekeeping, board housekeeping. So how would the public know that that's what was going to come up at the school board meeting? It just said board housekeeping. How would you know that this charter school was going to be the subject of discussion? And that led to a lawsuit. So also the question earlier about decisions being made, things happening outside of public meetings. There was a lawsuit very recently in Elbert County involving the commissioners. This was eventually ended up being settled. And the allegation here, and what happened is that the commissioners, the Elbert County commissioners, decided to give very big raises to the county administrator and the county attorney, and they did this outside of a public meeting. And so this lawsuit called them out on it, and eventually it was settled. So we don't have this great document from, or a judge's order explaining why this was a bad thing to do. I wish we had that, but that's a good example of what you're not supposed to do. These are decisions, spending public money, giving raises to your two top officials in the county. That's something that's supposed to happen in before the public, and those deliberations and decisions should be made in a public meeting.
Okay, I have a couple questions in the chat.
Yeah.
Let's see, or a few. Does every entity decide how much to charge citizens for FOIA requests? How is FOIA different from FOIA?
Yeah, so Cora, and we're really talking about the open meetings here and not Cora, but so in Colorado, we have the Colorado Open Records Act as opposed to FOIA. FOIA is the federal law. And in Cora, there is a maximum hourly rate that governments can charge. It's $41.37 an hour after the first hour, which must be provided for free. I have written extensively about this because that hourly rate is tied to inflation and went up last July 1st, 23%. And we have tried to get the legislature to reevaluate the way that's calculated. And so far they're not willing to do this because it can make public records requests very expensive. You take that rate and multiply it by 5, 10, 15, 20 hours. And soon you're talking about hundreds or thousands of dollars to obtain public records.
Right. Okay, and then Jan would like to know what constitutes authorization for an executive session?
Yes, I'm going to get into that.
Okay.
That's still coming.
And then Kathy Marr, she's a member of Larimer County Advisory Board, and in our mandatory annual training, we have it drilled into our heads that any meetings of 2 or more members in which public business is discussed must be open to public. So she's confused by the threshold of 3 for local governmental and public bodies.
Well, it's 3 or more. That's what the statute says for a local public body. If the Larimer County Advisory Board is an advisory board to the county commission or the county in general, it's 3 or more.
Thank you for that.
Sure. And I can push you to the statute if you need. I'll make sure that everybody has my email address at the end. If you ever have questions for me, that's what I do all day. So I'm happy to answer those. So I mentioned earlier the lawsuit against the Douglas County Commission, and that actually has not gone well for the plaintiffs so far. It's now in the Court of Appeals. But this is over the issue of home rule and whether Douglas County is going to become a home rule county. There's an election set for later this month about that. But the commissioners seem to have made this decision completely outside of public view in a series of executive sessions and other types of meetings, and had like 30 seconds of discussion in public about this. And so it is, if you read the lawsuit that was filed, it seemed pretty obvious and there's apparently more proof of that. So that proof. Emailing and text messaging. So as I mentioned earlier, and we're not talking about the legislature anymore because they changed the law as it applies to them. But any other public body in Colorado, if they communicate by email or text message, and for a local public body, 3 or more or a quorum are doing this or fewer, so that 2-person county commission or that 3-person county commission, 2 or more members, if they're discussing public business by email or text message, it is a meeting that the public can't attend. You might be able to do an open records request for those messages, but that's after the fact. The point of the open meetings law is your attendance in real time. That's what you're entitled to. You're entitled to attend the meeting. So if they're emailing and text messaging, you can't attend that meeting unless they somehow figure out a way for you to do that. I don't know what that would be. There is, however, a way that elected officials can email about certain things. So scheduling, their availability for meetings, sending a piece of information to everyone, as long as they do not discuss the merits or substance of public business, then they can do those things in a very limited way. But they're not supposed to be communicating that way. Often you as the public will never know about this unless it comes out because someone's made an open records request. And that happens from time to time. Public members of public bodies do this on sometimes, maybe not thinking about the open meetings law implications of it, or thinking they're not going to get caught. So a very recent story, just 3 months ago, has had and this is necessarily an open meetings story, but it goes to how public officials now in 2025 may be communicating. So Signal, as we know, became this sort of national story because of the new Secretary of Defense and the now former National Security Advisor using Signal, and bringing in the editor of the Atlantic into their discussions. Well, about the same time, the mayor of Denver and many of his top advisors were using Signal to communicate about Denver's immigration situation. It's not an open meetings violation because you're not really talking about a public body, but I throw this in here because we just don't know often how they're communicating, and if they're using Signal, which allows messages to automatically delete after the person receives them, then there wouldn't necessarily be a record of that. So we could have, and I think this does happen, we could have members of public bodies communicating this way, meeting this way, and you'd never know it. We put out a report that a University of Denver law student did for us in 2023, so before all this stuff, saying that public officials should not be using these disappearing messaging apps to conduct public business. because of the open meetings law implications, the possible implications, and also the implications for the open records law. Because if you communicate by disappearing messaging app, there's nothing to do an open records request for. And that defeats the purpose of the open records law. So far, they haven't listened to us when we've advocated for this.
Okay.
Yeah.
Kathy Marr said that Signal doesn't delete messages by default. The user has to choose that option. for
Yeah,
auto
and that's what they were doing.
delete.
They
Yeah.
were choosing that option. Brian Moss, who's a reporter for CBS, who's been on the job for many, many years, really good reporter. He found out about this because one of his sources, tipped him off to some email communications about this, about their use of Signal, and he made a Quora request and found the smoking gun. But yes, it can be set various ways. We talked about that Douglas County school board case a little bit, and that was an example of what's called serial or daisy chain meetings. So this is not something that is, if you looked in the open meetings law, that you wouldn't see a section about serial or daisy chain meetings, but it has now come up in a couple of lawsuits. And what this basically means is that you can have a public body could have a series of one-on-one meetings where they communicate their feelings about something or their position on something. Two of them do to a third, and then a fourth or a fifth, and it's essentially the same thing as having a meeting with three or more. So it has the same effect as a public meeting that should be open to the public. So in the case of those four Douglas County school board members who eventually decided to fire the superintendent this way, that's what the judge found. That even though two of them were talking at a time, and then they relayed their feelings about the superintendent to a third and then a fourth, that was a meeting under the open meetings law that the public could not attend. Executive sessions. We had a question about executive sessions. I'll go over that a little bit. So one thing to keep in mind right off the bat with executive sessions is that they must be properly announced. And we have some case law about that. Really, three things need to happen before a public body can convene an executive session. They have to first cite the authorization in the open meetings law that allows an executive session on that particular topic. Then they have to announce to the public during a public meeting the particular matter to be discussed in the executive session in as much detail as possible without ruining the point of closing the door on the public. And then they must take a vote to go into executive session. So those three things must happen in order to properly convene an executive session. So all that has to happen in a public setting. So the public, the community has an idea why their elected officials are closing the door on them. And so there are various topics that can be discussed behind closed doors. And for a state public body, and once again, we're not really, I mean, I guess it still does apply to the legislature, but they don't really go, committees every once in a while might go into executive session, and you see that with like the leadership committee, the executive committee of legislative council, or the legal services committee go into executive session sometimes. So property transactions, getting advice from their attorney on specific legal questions, specialized details of security arrangements, matters that are required to be kept confidential. So
Sure, the Danes will have something to say about that.
I'm sorry, is there a question? Oh, okay. So documents that have to be kept confidential, that type of thing. For a local public body, a lot of them are also pretty similar, but personnel matters is one of those things that they can go behind closed doors for. But the employee that they're talking about has to be given an opportunity to have that meeting in the open if they want to. If that person, school board, if they're discussing individual students, they can do that behind closed doors. If they're determining negotiating positions, that's really the only time they can actually sort of decide something in an executive session, is a negotiating position. Otherwise, a public body is not supposed to make decisions in an executive session. So here's an example where that was not done properly. We had the Denver School Board a couple of years ago when a student shot two administrators at East High School, which is just a couple of miles from my house and where my daughters went to school a long time ago. The Denver School Board went into executive session for 5 hours the next day. And they came out of that executive session with a brand new policy, written policy about having armed police in the high schools. Before that, they weren't allowed allowing that. And so that was going on. I actually started to get a bunch of emails and phone calls from reporters saying, "Can they do that?" And they couldn't do that. So about 6 news organizations filed suit against the Denver School Board. And the judge actually found, before even getting to that question about wrongly making a decision in executive session, that they had not announced this executive session properly. They just said this was happening for detailed arrangements of security procedures. And what they needed to do was actually tell the public that they were going to discuss this policy on armed officers in schools, which actually is not an authorized topic for an executive session. That's a policy question. They could talk about certain, security things behind closed doors, but the policy question, that's a matter for a public meeting. And so the judge in that case released the recording of the executive session for the public to hear. So executive sessions must be recorded, and those recordings must be kept for at least 90 days, except the portions of executive sessions where they get advice on legal questions from their attorney do not have to be recorded. So when that can be frustrating sometimes when you believe that it was an improper executive session when they've gone in and they didn't really get advice from their attorney. They talked about policy, and there may not be a recording for a judge to listen to.
Okay, I have a question from Jan. Is there any law determining when public comment must be allowed?
No. So that has come up very, very often recently because public comment has become very difficult for a lot of public bodies. The Aurora City Council just stopped its public comment section and decided to meet completely online because every meeting has been dominated by people protesting the police killing this man named Kylan Lewis. And that's been going on for about a year. And the Aurora City Council has been just really frustrated, not knowing how to handle this. because there's been a lot of disruptions during the meetings. There's nothing in the open meetings law that says anything about public comment. Public comment is something that each public body decides to do or not to do. If they do it, it has to be done, and there are court rulings around the country about this. It has to be done in a way that treats everybody the same. So it can't be done in any kind of viewpoint discriminatory way. They can set certain rules for a decorum. So, if somebody's really disruptive, they can be, told to leave. They can do things like say, we're going to do this, give everybody 3 minutes or something like that, a piece. But those rules must be applied equally to everybody. We do have some information in that guide that I showed you about public comment on our website. So this is another fairly recent ruling about a decision that took place in an executive session, and this is the fire board in around Estes Park. And the newspaper, one of the newspapers there, the Estes Valley Voice, which is about a year-old nonprofit, sued the fire district for hiring its new chief in an executive session. And they did it because they filed a lawsuit because they wanted to hold them accountable for doing this in a secretive way, something that was supposed to be done out in public view. And they won. So common violations of the Sunshine Law, just to go over some of the things that I've been talking about. Making decisions in an executive session, discussing public business by email, text amongst a quorum or 3 or more members, whichever is fewer, of a local public body. Once again, the legislature changed this law as it applies to them. They can do this now. This hasn't happened in a while, as far as I can tell, but it was happening several years ago, where public bodies were using secret ballots to fill board vacancies. So you can't use a secret ballot to make a decision. A public body cannot do that. The only time they can use a secret ballot is to actually choose their leadership. So in some places where the mayor is picked by the board itself, you can use a secret ballot for that, but you can't use it for any other kind of decision making. Failing to follow the proper procedures for calling an executive session, discussing unauthorized topics in an executive session. Once again, that's really hard to get that evidence unless you got someone on the inside telling you that it happened. Serial or walking quorums, like happened with the Douglas County School Board, and that, discussing something that's not authorized. So those are the sort of the main things. What can happen if you actually took a public body to court? There's not a ton of teeth in the law, but like what happened with the Denver School Board, you could get that recording released. That's probably the main thing, because then you actually can hear and how, what they were discussing behind closed doors in violation of the open meetings law. So that's like a tangible piece of evidence, and hear what, a discussion that should have taken place in public. Any action that was taken in an illegal meeting could be invalidated. A judge could say, don't do this anymore, an injunction. And then, of course, something that's really important in both the open meetings law and in the open records law is if you win, you are entitled to your court costs and your attorney's fees. And so that is the thing that is really powerful, because if you didn't have that guarantee of getting those court costs and attorney's fees, you probably wouldn't go up against the government and file a lawsuit. It would be even more intimidating than it probably already is. But the fact that you can get those is really important. And going back to that Pagosa Springs attorney, who files a lot of these lawsuits. The legislature was so mad at him, they tried to change the open meetings law to say that he couldn't get any fees if he won these cases. But we fought that because once you do that, that just ruins the whole point of having a law, I think. So yeah, that's my presentation. And I will, let's see. I will take it off of share screen. And there we go. And I'm
Okay.
going to put, I'm going to put my email address in the chat.
Okay, while he does that, does anybody have any last questions you want to ask?
I have a hotline question.
Sure.
Go ahead.
So in Wellington, which we've been covering for a while, the town of Wellington has had some significant problems with the price of water and utility rates going way up. People have had to take loans to pay them. And so a citizen group was appointed to convene to discuss this. And the town is allowing them access to the historic records of what fees have been for the municipal utilities. And the group has been meeting for a while, and some people had asked that they wanted these meetings to be open, but the members, who are not elected, of course, they're just residents, but they are reporting to the Wellington board. They're like, oh, we'd rather it not be open. And the mayor said, okay, we'll keep it closed. I'm thinking that's probably wrong.
Well, they sound like an advisory board, do they not?
Yeah.
Yeah. So that definition of a local public body in the open meetings law would include an advisory board. I mean, if you want to know exactly what it says, I will go to my guide and get the definition of that. So the wait, jurisdictions, there we go. So the definition in the open meetings law says any board, committee, commission, authority, or other advisory, policymaking, rulemaking, or formally constituted body of any political subdivision of the state is a local public body. It sounds like that is, whether they want to, have their confidentiality or not. It sounds to me like they're a local public body.
And so they would be in violation.
Yeah, and I think that they, the way to treat it is probably to ask them why that definition of local public body does not apply to them, why they think that.
Okay.
I have a question. Have you heard of any local public bodies who may want to follow suit and do what the General Assembly did? Because that's what I think is one of the unintended, really bad consequences of what the General Assembly did, is they're setting a really bad precedent for all these other public bodies to exempt themselves from the open meetings law.
Yeah, I mean, I hear that a little bit, but I haven't heard anything concrete or that there's going to be any kind of proposal like that in the legislature. It would take legislation to do that. And we would very much oppose that.
Yeah. Okay, well, this has been great, Jeff, and next time you have to come and talk about Open Records Act.
I've got a bunch of slides about the open records law and about the criminal justice records law, and we can do that sometime as well.
Okay, great. Okay. So thanks everybody for attending, and thank you, Jeff. And
Okay.
good night.
All right. Thanks for inviting me. Bye.
Sure, thank you.